going to start off with Grant Griffith. He's a patent attorney who concentrates on patent prosecution in various high-tech areas like distributed storage systems, cloud computing, robotics, and optical networks. Grant also advises clients on competitive landscapes and the freedom to operate. Welcome, Grant. We will also hear from, let's see, I'm going to go start on the left and go over to the right. We have with us Brett Kruger. He's an intellectual property attorney with extensive experience across a broad spectrum of technologies, including robotics, AI, and virtual assistants. He helps clients with patent prosecution, licensing, and managing infringement risks. And next to him, we have Ryan Christensen, a registered patent attorney with a background in automotive engineering. Ryan focuses on preparing and prosecuting patent applications for a wide range of technologies, including AI, large language models, and cloud computing. Next to him, we have Chris DeLuciane, a patent attorney with over 10 years of experience in the avionics industry. Chris specializes in patent preparation and prosecution, particularly in electrical and software systems, with a deep expertise in ex parte appeals and drafting appeal briefs. Next to him, we have Catherine Niedermeyer, an intellectual property attorney who brings her engineering background to assist clients with patent procurement strategies in fields like speech processing, distributed storage systems, and digital therapeutics. She focuses on domestic and international patent strategies. And finally, we have John Chow, an experienced patent attorney who specializes in patent strategies across industries like automotive, medical device, and software. John brings a unique perspective on navigating U.S. and Japanese patent laws, and he is actively involved in the IP practice in Japan committee of the AIPLA. Thank you to our very knowledgeable and experienced panel. I'll turn it over to Grant.
Thank you, Esther. Okay, what we're going to dive into is inventorship of AI-assisted inventions. And to be clear, this is the use of AI assisting in the conception of inventions and not inventions covering AI concepts. So just a little background is patent applications have one or more inventors, and they have to be a natural person. So the take-home of this segment is if an entity is not a natural person, they cannot be named. It cannot be named, such as AI, could not be named as an inventor or joint inventor. So now with the advent of generative AI, really the USPTO has come out with some guidance this past February, and just on how to treat AI inventions. It's going to be evolving, but right now, I guess the main take home is it's not categorically unpatentable for improper inventorship if you use AI-assisted inventions. We dive into these PNU factors, which is from a 1998 Federal Circuit case for inventorship, and we really focus on the concept of contribution and significant contribution of inventors in the conception and reduction of practice of an invention. And this says 5 guiding principles, but there's 3 we'll close with, and everything applies to utility, plant, and design patents. Let's skip that. This gets a little redundant. So these are the PNU factors that I mentioned. There's 3 of them. It's really the first 2 that we focus on for AI-assisted inventions. There must be a significant contribution by each natural person, and they must make a contribution that is not insignificant in quality. And the third is really applies to, you can't be an inventor if you're a consultant or somebody help maybe solving some underlying problem related to the invention, but not an inventive concept. The first PNU factor is each named inventor must contribute in some significant manner to the development of the invention. So, or the conception and reduction of practice. There's this note that if you're just reducing something to practice, that's not going to be a significant contribution. But I think this is going to get really muddy in the future when we move from dumb AI to AI that can reason and make decisions outside of its training domain. So there's going to be ways to apply these AI outputs, and somebody's going to recognize that there is an invention there, an inventive concept. So I think it's going to be evolving. Two, just in summary, it's somebody's contribution. It can't be insignificant in quality. So if we're using AI to, I don't know, say develop a new pharmaceutical compound or something, if there's an engineer that's just formatting data going into the AI, or doing something that's just general knowledge for somebody skilled in that area, it's not enough to be significant for a contribution. It has to be more, and it has to go towards the conception and reduction of practice. The third, as I mentioned, just experts in the field that contributed to insight in the development process of an invention or conception. That's not enough to be significant. And we're going to go through these just last principles to close out. So, the key is a natural person's use of AI in creating an AI-assisted invention does not negate that person's contribution as an inventor. Two, it's just merely recognizing a problem isn't enough, and we're going to see when Ryan comes up, he's going to give a specific example of applying the PNU factors. But I do want to point out this one caveat is, these prompts are really detailed in a lot of circumstances when there's a problem. A lot of people think a prompt is just one sentence. That might be how we use in our personal, use cases with ChatGPT, but prompt could be like multiple pages long with few shot learning examples and different techniques. So they can be structured in a way that is going to be inventive and significant. So you could have a problem, but the way you structure a prompt could be enough to be an inventor. And then three, I kind of touched on this, reducing an invention to practice alone isn't enough, but this kind of goes in with how things are prompted. And then, as I said, as AI advances, people are going to recognize as new things solved by AI through reasoning and on their outputs, and that might lead to inventive aspects as a significant contribution. All right, I'm going to pass it to Ryan to give a specific example.
Good afternoon, everyone. My name is Ryan Christensen, and I'll be following Grant's discussion on the legal framework and USPTO guidelines regarding AI-assisted inventions by presenting a practical example that highlights some of these principles. Our case study today revolves around the AI-assisted invention for an avocado chair. So let's start with the facts of the case. John and Kathy are engineers at a seating company, and they prompt an AI system to create an initial design for an avocado chair. The prompt they used here was simple: create an original design for an avocado chair. The results generated by the AI system produced a design with a seat bottom, a seat back, and a lumbar support, with the design resembling the shape, color, and texture of an avocado. Now let's analyze whether John and Kathy are proper joint inventors of this claimed invention. Claim 1 in the patent application recites a seat with a textured skin resembling an avocado, a seating surface resembling the flesh of an avocado, and a lumbar support resembling an avocado pit. Now, with respect to Claim 1, John and Kathy's contributions were limited to recognizing the need for an avocado chair, prompting the AI system to create a design for the avocado chair, and reviewing the output of the AI system. These actions do not meet the criteria required for inventorship under the first PNU factor that Grant just talked about. That factor requires a significant contribution to the conception of the claimed invention. Here, John and Kathy simply just recognized the need of a problem, prompted the AI system, and used the output without contributing anything more. For those reasons, John and Kathy are not considered proper joint inventors of Claim 1, as the AI system is the actual inventor of Claim 1. Now, let's look at a second claim of the application, which includes all the limitations from Claim 1 and additional details regarding the materials used for the avocado chair. Here, John and Kathy reduced the invention to practice by building the chair according to the AI-generated design, and they also selected materials used to build the chair. The materials they selected include a plush seating surface, a hard outer shell, and wooden legs. With respect to Claim 2, John and Kathy's contributions are limited to building the chair and selecting well-known materials to build the chair. And these actions are also not enough for inventorship. And for those reasons, John and Kathy are also not proper joint inventors of Claim 2. Finally, let's consider a third claim, which includes additional details regarding significant modifications John and Kathy made to the avocado chair. Here, in addition to the AI-generated design, John made the lumbar support removable and designed a mechanism so that it could attach to the seat in various different positions. And Kathy designed the lumbar support so that it could move vertically with respect to the seat. These contributions were covered by Claim 3 of the patent application. And in this case, John and Kathy's contributions are substantial. The modifications provide a significant contribution to the claimed invention in addition to what was produced by the AI system. These contributions satisfy all three of the PNU factors. They are significant to the conception, result from experimentation, and are not merely explanations of well-known concepts. Therefore, John and Kathy are proper joint inventors of this third claim of the patent application. In conclusion, the determination of inventorship in AI-assisted inventions depends on the nature and significance of the contributions made by the individuals involved. Simple actions like recognizing a problem, prompting the AI system, or using the output of the AI system are not enough for inventorship. However, making substantial modifications and contributing to the conception of the invention can establish inventorship. Thank you, and I'll now hand over to my colleagues Chris and John, who will present on the next topic.
Good afternoon, everyone. My name is Chris DeLucini, and I'm a patent attorney with a practice that focuses on software patents. And for this portion of the presentation, my colleague and I will explore the considerations for patenting machine learning inventions, focusing specifically on subject matter eligibility under 35 U.S.C. 101. So as opposed to the previous presentation where the AI is the inventor, here you're actually trying to patent something that includes the AI. So this is a critical area, as machine learning inventions often fall in a gray area regarding subject matter eligibility. And based on recent guidance and case law, the difficulty in obtaining patents in this area is increasing. So with this in mind, we will first broadly discuss what to look for when deciding whether to pursue patent protection for AI inventions. And then in more detail, we'll review USPTO guidance and provide specific strategies for drafting patent applications. So to begin, let's understand the key point of subject matter eligibility. 35 U.S.C. 101 is a section of the United States Code that defines patentable subject matter in the United States. So under 35 U.S.C. 101, inventions must be at least one of the following: a new and useful process, a machine, a manufacturer, or a composition of matter. However, courts have decided that there are some exceptions to these categories. And these exceptions include concepts such as abstract ideas, natural phenomena, and laws of nature. Now, the challenge with machine learning inventions is that they often fall into this gray area of abstract ideas. So in the context of subject matter eligibility under 35 U.S.C. 101, an abstract idea typically refers to concepts that are not tied to specific practical applications or a concept that merely automates a conventional process without adding any inventive concepts. So an example of abstract ideas relevant to machine learning includes things like mental processes, which is a task that a human could perform mentally or with pencil and paper, and concepts such as mathematical relationships and formulas. So now, to ground this definition in an example, let's consider a scenario where a machine learning model is used to automate a conventional process. For instance, using a large language model to generate standard business reports. So in this example, the invention would include collecting data for the report, generating a prompt for the model that includes the data, and then having the model actually generate the report based on the prompt. So this type of invention is unlikely to be patentable on subject matter eligibility alone because it lacks an inventive concept beyond the abstract idea of report generation. Essentially, it is merely automating a conventional process without adding any novel or non-obvious techniques. So on the other hand, let's look at an example that is more likely to be patentable. So imagine there's a novel method for generating prompts and utilizing the output of a machine learning system to create personalized educational content based on student data. For example, during a lesson, the invention generates prompts from students' questions and comments, and then the model generates modifications to a lesson plan in real time. So this invention would have a specific practical application and would involve real-time adaptation, making it more likely to be considered patentable. It demonstrates novel and non-obvious techniques applied in a practical context with tangible benefits. So to increase the likelihood of patentability, machine learning inventions should include the following elements. First, novel and non-obvious techniques. The invention should introduce new methods that are not merely automating conventional processes. Second, specific applications. The invention should be applied in a practical context with tangible benefits. Third, technical improvements. Ideally, the invention should demonstrate specific improvements to technology, such as how a computer operates. For example, the invention could demonstrate enhanced accuracy or increased efficiency or better functionality. Finally, detailed implementation. The invention should focus on novel or non-obvious elements of the data gathering, the training, prompt generation, and use of the model's output in explicit detail whenever possible. So in summary, when seeking to patent machine learning inventions, it's crucial to focus on specific applications with tangible benefits, technical improvements, and detailed implementation. So next, my colleague John here will provide additional background on recent USPTO guidance and specific strategies for preparing patents in light of this guidance.
Good afternoon. So in July of 2024, the USPTO issued some guidelines on subject matter eligibility as it relates to AI patents. In addition, they also provided the guidelines on AI-assisted inventions, and then they provided examples. So we're going to focus on the patent subject matter eligibility as it relates to artificial intelligence. It was really a boring read. But there are two takeaways, all right? And what they're trying to do, the USPTO is trying to focus everybody on this aspect of AI being, there to solve a problem. So as part of that, they want you to draft a background that details what the problem is. And then when you draft claims, you need to draft claims such that they address the problems and they show the steps that are necessary to solve the problems. This can get you a patent, but I think we all know that doesn't necessarily mean it's not subject to validity attacks in court, right? So the genesis of this is focusing on step 2, prong 2. And the reasoning behind this, as I said, is the USPTO, as you can see, correctly identifies as AI patents being improvements to current functionalities of current programs and products that we have. So in the discussion of what is required, the USPTO referred to example 47. And example 47 relates to basically a method for detecting an attack on a network software. And so it has these steps of using an artificial neural network, and then that's kind of like the AI, and everyone understands that artificial neural networks are basically just a function of mathematics and programming. And then you have these other steps of detecting and determining and dropping. And so when we do our analysis, one of the things that we always have to ask ourselves is, are there any additional elements that are recited that take the application beyond the judicial exception? So just beyond the pure math of the claim in this case. So beyond just a neural network. And here we look at the steps of detecting, dropping, and blocking. Those are things that are done that it's not just necessarily a mathematical concept. So yes. And then when we look at this, we determine whether or not that these steps collectively, they integrate the claim or the judicial exception into a practical application. And so what the USPTO said was, we've in the past had a lot of different arguments for integration. And the USPTO said, well, let's take a look at, what the problem is and whether or not your claims provide the steps for overcoming the problem. So in order to do that, they looked at the specification and whether or not the specification, set forth an improvement in technology, and then the claims showed the steps to those improvements. And here in example 47, we have this issue where the background describes, a problem regarding malicious attacks on a network. And then in the summary, they talk about the steps that we're going to take to solve this problem. Now, when they looked at the claim itself, they looked at these steps, and they said the steps of detecting, dropping, and blocking are all things that are beyond just the use of a neural network itself. And by doing so, they said that the USPTO said that these are the kind of steps that meet the element of integration into a practical application. So the bottom line is that when you're drafting applications, the more detail that you have in terms of how you're going to solve a problem, the better off you are in terms of the claims. Next is Catherine.
Thank you, John. Hi, I'm Catherine Niedermeyer, and I'm here to discuss guidance on the use of AI tools in practice before the USPTO. Okay, so just as an introduction, this guidance was issued by the USPTO in April of 2024, and it was to inform the public and practitioners about the use of AI tools in patent and trademark practice. Generally, this was meant to highlight the responsibilities to ensure compliance with the existing rules and to mitigate risks. However, it was not intended to announce any new USPTO guidance or provide an exhaustive list of issues. As some context, this was issued in response to increasing integration of AI tools in various sectors, including legal practices, and it was also in response to an executive order issued in October of 2023. The guidance begins by providing an overview of the USPTO's existing rules and practices. So these are not changed by the guidance, these have always been in effect. Specifically, it starts with the duty of candor and faith. This applies to all individuals associated with proceeding before the USPTO and includes the duty to disclose all information known to be material to patentability or trademark registrability. The guidance additionally touches on the signature requirement and corresponding certifications. These apply to most correspondence filed with the USPTO and require that the person inserting the signature or submitting the paper is certified to the truthfulness, accuracy, and legal sufficiency of the paper. The existing rules additionally address confidentiality of information, namely that practitioners are required to maintain the confidentiality of client information and to prevent the inadvertent or unauthorized disclosure of access to such information. The existing rules and policies include the foreign filing licenses and export regulations that require practitioners to obtain a license from the USPTO before filing a patent application or exporting any technical data related to an invention made in the US to a foreign county or authority. This also requires that practitioners comply with the export regulations of other federal agencies, including the Department of State and the Department of Commerce. Continuing with the existing rules and policies, there are USPTO electronic systems policies, These require that a user registers for and uses a USPTO.gov account to access and file USPTO documents. This also requires users to abide by the terms and conditions of such systems, including the prohibition of unauthorized access or use of such data. The existing rules and policies further include duties owed to clients. These are to provide competent and diligent representation to your clients, consult with your clients about the means and objectives of the representation, keep abreast of the benefits and risks of relevant technology, and supervise the work of others, including practitioners and assistants. The guidance goes on to enumerate how we can apply the existing rules to the use of AI tools and gives a few examples. When addressing document drafting, the guidance notes that there is no prohibition or general obligation to disclose the use of AI tools, for example, in drafting patent applications, trademark applications, or office actions. However, parties and practitioners must review and verify the documents and their contents. With respect to filing documents with the USPTO, there is no prohibition in using AI tools. However, parties must continue to ensure compliance with the signature requirement and corresponding certifications, as well as the existing rules that were previously discussed. When accessing USPTO IT systems, the guidance notes that there is no prohibition on using AI tools. However, practitioners should ensure compliance with the USPTO's electronic systems policies, the confidentiality of information, and the foreign filing licenses and export regulations. Additionally, practitioners should avoid exceeding authorized access or violating federal or state law. The guidance continues by addressing confidentiality and national security considerations. Practitioners should stay aware of the risks of inadvertent disclosure of client-sensitive or confidential information to third parties through the use of AI tools. Further, with respect to fraud and intentional misconduct, the USPTO notes that it does not tolerate fraud or intentional misconduct in any proceeding before the USPTO or in connection with accessing USPTO IT systems. The guidance continues by addressing implications and limitations of AI, specifically that AI tools used in practice can improve quality and efficiency and accessibility of services. However, practitioners should be aware that AI tools pose potential risks, such as inaccurate, incomplete, or misleading information, and that the inadvertent disclosure of confidential or sensitive information to third parties is something to be aware of. Further, AI tools are not infallible, and their outputs have limitations that will affect their performance. The guidance concludes by offering some practice pointers that we can glean from the existing rules. Specifically, that practitioners should continue to understand the capabilities and limitations of an AI tool before using it. This means knowing and being aware of the terms of use, privacy policies, and the cybersecurity practices of the providers of the AI tools. Additionally, practitioners should always review and verify the accuracy and completeness and relevance of information generated or assisted by AI. Practitioners should disclose any material information related to the use of AI tools to the USPTO, clients, and other relevant parties as appropriate. As always, practitioners should maintain the confidentiality of client information, and they should prevent the inadvertent or unauthorized disclosure of such access to information and supervise the work of other practitioners and assistants who use the AI tools to ensure that they are continuing to comply with the professional obligations and the USPTO rules and regulations. In conclusion, in the guidance, the USPTO recognizes that there are benefits and risks of AI and expects parties and practitioners to comply with the USPTO's existing rules and policies. They will continue to engage with stakeholders and monitor the use of AI, and the MPEP will be updated accordingly. Thank you. Now I'd like to introduce Brett Kruger.
Thanks, Catherine. I'm Brett Kruger, and I am a patent practice group leader in the intellectual property department. I used to be a software engineer for many years, became a patent attorney, and I've been prosecuting patents on software for about 2 decades now. So far, we've learned about inventorship for AI-assisted inventions, patenting AI-related inventions, using AI tools in patent prosecution. But in this last segment, we're going to talk about data concerns for AI tools. And in particular, I'm going to talk about assessing AI tools for your practice. I'm trying to get the mic so I'm not so echoey. So you've probably all figured out by the whole morning session and everything up to now, AI is an assistive technology. And I say assistive because that's what it is. Basically it's assisting you when used properly to be more efficient and more productive. But how do we know which AI tools to use for our practice? Well, besides choosing from various functionalities, we need to determine which tools adequately protect the privacy and confidentiality of our data. So in patent prosecution, we need to make sure that our data practices align with legal standards to protect intellectual property rights. So what tools are safe? Safe's a relative term, and in the patent world, we call it an indefinite term. So you need to define what meets your minimum requirements to allow you to use a tool comfortably. I mean, one example is to use email. Is that safe enough for you? If we had the guy from Rocket Mortgage up here earlier, the software guy, he probably could go into some aspects of software, of email, could say, well, this part of email might not be adequately protected, and other people might think it is. So when assessing your AI tools for your practice, I think you should consider the following data management techniques. One is end-to-end encryption. 2 is separate storage, and 3 is only allowing training access to your data via fully federated techniques. Now that's a technical term, and you guys are all still awake, and after hearing everything about patents, I always tell people, if you have a hard time falling asleep, go read a patent. You'll fall asleep pretty fast. So for models undergoing active training, federated learning prevents unauthorized access to your raw data, and while still allowing model training. So there's a lot of new AI startups out there. They're all popping up, and a lot of them have just a few employees. You need to ask them, are they aware of these techniques? Do they have the resources to implement them? So end-to-end encryption is encrypting your data at rest when it's stored, when it's saved in storage, and also while in transit between nodes in a network. Unencrypted data is vulnerable to a man-in-the-middle attack. This is where somebody intercepts your data while it's in transit on the network and can alter it, take it, and use it in ways you don't want. Many AI tools use several models. While some of the models are closed, not being actively trained on data, others are continuously being trained to refine the user experience of that tool. For AI tools that are being continuously training or still undergoing training, federated learning offers a way to train without direct access to your model. Instead, model parameters are set based on your data and then encrypted and transmitted via secure channels. The key takeaway on that is that they're not accessing your raw data. Now, while federated learning protects your raw data, very sophisticated hackers could try to infer aspects of your data through intercepted model parameters, for example, that man-in-the-middle attack, if you weren't using your end-to-end encryption. And it's hard, when things are evolving and what's fully secure, what's not secure, we recommend if you have trade secrets, just don't put them out there. Don't use them in anything right now. And panelists in the morning alluded to that as well. But if you want to add an extra layer of security, you could consider fully homomorphic encryption, another big technical term, but it's a really high level of encryption that could further mitigate privacy risks. So we discussed various ways to protect your data, but for those who have consumer products, you should also be aware of the CCPA, the California Consumer Privacy Act, and the GDPR, the European Union's General Data Protection Regulation. These are 2 big topics of their own. I'm only flagging them for you, for completeness. We're not going to go into those now, but I wanted to bring them to your attention so that you're aware of them, so someone can't say, well, you didn't mention those. But this concludes our afternoon session. Thank you so much for staying here and listening to it. It was very technical in nature. For those who are IP attorneys probably found it interesting, and those who aren't IP attorneys, thank you for staying awake. Any questions? Alex?
I guess we're on microphone, but
He's got one.
yes. Thank you. Here we go. So my question comes from being a patent practitioner, but hopefully this helps clients as well. And I'm sorry if this is more than one question, but if our client comes to us and they say that they're using AI to help them generate their invention, or maybe their invention uses AI along the process, what information should they be providing to us so that we can help them help themselves when it comes to inventorship and patentability?
All right, we did a segment on that. Who wants to answer that one? Grant? This should be a microphone right there next, in your seat. It should be on.
All right, yeah. Thanks. Yeah, thanks for the question. Usually in the record of invention, they should disclose how the invention was conceived and which tools were used. It's kind of depending on the client. I mean, if we're advising, we would recommend it to give us all the input so we can know who can properly be named as a natural person, an inventor that is a natural person, so that we know if there was a significant contribution or not. The last thing we want is a patent that's been in use to be litigated and then find out that it's unenforceable because of a lack of an inventorship.
For those of you litigators out there, I know you guys attack inventorship, so this will be a new tool for them. Any other questions?
Brett, I have one for you.
Oh.
Brett, on that, do you recommend that we keep a log of the iterations that is used when you're prompting an AI system? Do you think that is something that we should be keeping, asking or telling clients to keep a record of?
Repeat the question for him, Grant, when you answer it, so the audience can hear it.
I'm sorry, could you repeat it real quick, Eric?
Yeah. Are we recommending that when you're using Are we recommending that when you're using an AI system that you keep a record of the prompts that you're putting into the system? Because I know in part of the earlier discussions it was the significant contribution, and that iterative process of prompting could be relevant to how significant was the contribution on the front side of the invention process.
I don't think it would hurt, but I think when we draft the patent application, those sorts of aspects are going to be disclosed, and they're going to be revealed of how it's not an AI-generated prompt, it's a human-generated prompt, and how it's structured. I think it's going to lay itself out as satisfying or not satisfying the PNU factors. But just having a record of it, I think it's going to be sufficient for the practitioner to describe those aspects because they're contributory towards the conception and underlying aspects of the invention.
All right, there was another question over here.
Yeah, given the high level of uncertainty about the patentability of method patents involving AI at the moment, are you recommending to your clients that they move forward with the patenting route, or are you suggesting to them these days to basically publish on the patents and put it out as prior art with the hope that it becomes a defensive use of that patent?
Well, we've been patenting various aspects of machine learning AI for almost a decade now, so I would say there's a lot of patentable aspects. And if there's aspects that you think are questionable, the patent office has gotten pretty savvy on knee-jerk 101 rejection of this isn't patent eligible. So during the prosecution of the application, hopefully attaining an allowance and an issuance, you've fleshed out those issues, and the patent office is comfortable with what you're obtaining your patent rights on are patent eligible and not ineligible. Go ahead.
Just wanted to add on to that. I mean, there's also this other aspect of, when you're counseling your clients, how's the AI being used. And if it's somewhere in a black box and no one will ever know what the steps are, but they just get the benefit of the output, maybe you just keep it as a trade secret, and then you don't have to worry about, patenting it at all. And the other aspect is it, how are you going to know if someone is doing what you're doing? If all the systems around you are in this black box and it's just the output that the consumers are getting. So, I think that those are business considerations that, you should discuss with your clients before, going forward with a patent.
James, you have a question?
I was curious if any of you have heard any rumblings on any or how the USPTO is using AI to their advantage, and if there's been any skewing or changes in examiner statistics over the last year that you could maybe associate AI being used for.
I'm not aware of them using AI, but with the rollout of the DocX, they're clearly doing that so they can get everything in their databases and use it for examination purposes. That's my opinion.
Yeah, and just to tag on, there's speculation that examiners are using it because there's sometimes rejections coming back now with like 8 different references to support an obvious type rejection, and it just doesn't kind of add up of how an examiner is going to find these 8 references that easily, meet each element of a complex claim. So in my professional opinion, and I think they're using it, but they haven't disclosed that they are.
A question over here?
Just real quick, I sit on the patent search committee for IPO, and had a couple times we've had
Or here's a microphone for you.
USPTO, and we've asked them that specific question, right? It's like, what are you guys doing? And what they will admit to is that, well, we're using it for classification purposes. But they will also say, the examiners are free to use, and they won't say what, to help with their search. And then with that, I'd like to ask a question with respect to, drafting an application, as we were talking about. So you have an invention, and the inventors say, okay, we have this machine learning module or model, and from it, and you determine they've trained it, they have significant input, et cetera, and it generates or outputs a new material, let's say a polymer. So, they're using it to generate a new material. And then you think about it, it's like, okay, well, what's the improvement, right? And so what typically they'll say is, well, you could get there by what they call first principle calculations, which is, but they say that's very time intensive, computer, et cetera. So you say, okay, well, the improvement is enhanced efficiency or, reduces time, et cetera. So that's the improvement. Do you think in your specification, you can say that, right? This does it better. But do you think you need to somehow give a comparison? You compare it, say, okay, this is better in first principles, but do I need more than that?
Well, the easy answer is it doesn't hurt. If you can provide data,
right,
the more support for something. When we write applications, we always try to have the depth in there to have fallback positions or arguments for rejections that we think the examiner might make. So we can point right to the specification and say, well, right in the specification, we explain what this benefit is. And here's there's also a table showing the data illustrating how that's a benefit. And of course, that's, a good patent attorney will ask the client for this. Say, hey, I can foresee this coming here. Do you have any data on this? If you don't have any data, can you drive some data for us that we can put in this application? So.
Just to add on to Brett too, I find it a lot better to do the comparison with existing computer techniques and showing the improvement there. If you're showing an improvement with latency and time to how long it would take a human to do it, it's not that persuasive with examiners. So, but if you can show an improvement in existing computations or computer techniques, I think that goes a long way. And then I also know in Europe that they really like to see the data, the comparison. So a lot of times we prepare, most of our patent applications we prepare for our clients are multi-jurisdictional. So we try to be in compliance with the EP as well, who have generally stricter requirements. So if we pass muster there, we're usually good in the US.
We had a question here. No, that's answered. One more over here.
This might be kind of crazy. I'm not a patent attorney, but I was just thinking okay, you use the AI to come up with something, and it's not, you didn't do enough maybe. So somebody did enough, and it's AI, and that's not a person. But what about the person that made the AI? Could they make a claim for ownership in something because they made the tool that you're saying is really the thing that created it, not that person at the other end, or maybe like a joint between the person on the end and the AI creator? What do you think about that argument?
That goes to our, that was the first, that was Grant's and Ryan's presentation. That falls right in.
Yeah, I don't know how to answer that, to be honest with you.
Well, I think the answer is it'd be hard to say that there's joint inventorship, because in order for there to be joint inventorship, there has to be at least some sort of interaction between the two inventors. So for one, the developer who's making the AI would have no idea or interaction with whoever was using the AI later and prompting it to derive the result. So just based on the basic inventorship requirements of two joint inventors have to have at least some sort of, they don't have to be in the same place, they can be in different parts of the world, but there has to be interaction between them to jointly contribute.
So what if the patent gets denied because they say, no, this is all AI, like your beginning avocado chair scenario one, and you, the developer, sees that patent got denied? Can you say, well, then it's mine, I want the patent, because clearly, like, I made it. Somebody contributed, right?
No.
No. Okay. All right.
So there's this really famous case about a monkey taking a selfie, right? And someone tried to copyright that, and they couldn't because it was a monkey, not a person, right? So I think your scenario kind of falls into that same category where nobody's going to own it, and it's not going to be recognized as an invention. Just like that picture will not be recognized as having copyrights.
It falls in the public domain. Question over here?
Yeah, okay. So one of the, all of this stuff brings up a lot of really cool questions, right? And when you were talking, I think earlier, like when you looked at an inventor, we know AI is not an inventor because it's not a person, right? Mm-hmm. But can you also look to it as anything that's out of AI is really based on a large language model? So wouldn't it, or coming from other existing? So isn't everything obvious? So using it could never be an inventor, right? When you think about it from that perspective, it is the expert that you're just looking to for that information, or it's all of those things. So,
I see it in that scenario. AI is the tool,
right?
So, and that's how we apply the Pinu factors to see, if the natural person, made a significant contribution, if the, what they contributed was an insignificant manner, and you just go through those same steps because they're using it as a tool.
That has to be the only place where the inventive aspects can come, because everything else would be just a compilation of what's existing, right?
It's kind of, a tricky question, because a lot of times these large language models, I don't want to get too far in the weeds, but they're pre-trained. So everybody using GPT-4 is using the same model. In the way they manipulate it with prompts in engineering,
right,
that could be inventive. But there's also large language models where, a high-tech company develops this model to do a specific task, and they train it, and it's personalized in that manner. Mm-hmm. So that's inventive in its own right. So there's a lot. There's a lot,
and I guess that kind of goes to some of the question. I think someone said something about the USPTO. We were talking about what they were. I used to be an examiner, and it was many years ago, so there was not these AI concerns, but they're still held to the same obligations. So it's not. With them searching, they can't take it. It's, a lot of this is filed early, and it's not public domain yet, right? It will be published later, but it's not necessarily. There are certain things that are not necessarily public at the time, and so they're not dumping it into Google, They're dumping it into a closed system, and they may be using it within the system of what they have available to them, but they can do that anyways, right? So I don't think I think your 8, reference thing is probably a new examiner rather than necessarily a tool issue.
Yeah.
But the classification totally would work, because then it's keywords, right? So you're using keywords within your patent to get it classified a certain way, which is another tool that as a practitioner you can use. You can use keywords to make sure you are aligned with an art unit that's going to review it the way you want it to be reviewed, right? There are certain art units that are notoriously bad for allowance. Something to keep in mind.
Thank you. Any other questions? These are all great questions. And you guys are all awake. I love it. All right. Well, thank you so much for staying with us this afternoon. We appreciate it.